So generally speaking, as counsel is aware, the Charter guarantees certain rights and freedoms which cannot be infringed unless by some reasonable limits prescribed by law, and as can be demonstrably justified in a free and democratic society. So that's the basic framework that we work under, and then certainly the city must be compliant with the Charter, particularly Section 2B, which is the section dealing with freedom of expression, in exercising our control over city-owned spaces. So this would include injunctive relief, enforcing rights to exclusive use through permits, and by means of trespass notices. So when the courts look at whether an action or a bylaw or something undertaken by the city council or anybody really is consistent with the Charter, there is a prescribed analysis that the court goes through. And in particular, the Section 1 analysis. So generally speaking, they will assess whether there is a charter right that's in question or that could be violated. And then there's an assessment of whether those rights are reasonably limited. So they're not exclusive, they're not all encompassing. There are reasonable limits that can be placed on our charter rights, but there's a test in terms of whether that is appropriately done. So as I mentioned, Section 2B does protect all forms of expression, except where physical violence or threats of violence are conducted. Hate speech in particular is protected by Section 2B. So hate speech is considered a protected form of speech, but the courts have recognized that there are justified reasonable limits on that type of speech that does have a hateful content. So the definition of hate speech, so when we're looking at what this means, the courts will use an objective standard. So what would a reasonable person, looking at where the context and circumstances, would they view the expression as exposing a target group to hatred? And hatred is determined to be more than just humiliation or offense or discrediting. It's identifying detestation, vilification, such as blaming a target for all ills in society, looking at dehumanizing the target group, equating the target group with traditionally vilified other groups, and the effect of that speech is likely to expose the target group to hatred of others. So moving on to the criminal sections, so the criminal code provisions only deal with the most extreme forms of hate speech. Advocating genocide, hate speech that is likely to incite a breach of peace or violence. And so that's what the criminal code sections deal with. When we look at the evaluation of reasonable limits on the expression, the city-owned spaces, that analysis is going to be context dependent. So more limits on the speech are justified in more private spaces, so there's a spectrum. So if it's an office, somebody's office, there's more obviously limitations on what types of speech can be done in someone's private office as opposed to a public space. So obviously the more public the space, the greater the balance is in terms of the expression rather than the limits on it. And when you're looking at what kinds of limits, they have to be proportional and minimally impairing the rights. And that's the test that I mentioned earlier. So an outright ban forever is going to be obviously at one end of the spectrum, very likely to be found unconstitutional, versus a regulation of those speech, that expression, which is more likely to be found reasonable. So limiting time, space, occurrence, the types of things that when you're looking at a regulation as opposed to an outright ban, more likely to be found to be reasonable. The case law in terms of trespass notices in particular does reflect that type of analysis. So in the 40-year case that was mentioned, when an individual was was speaking things that the council didn't find to be appropriate, in that case they instituted a full ban for a year. So in that case the ban was not upheld. As I indicated earlier, the more outright the ban, and particularly in a public space, the more inclined the courts are to find that unconstitutional. But then you do have spectrum sort of moving to the other end when you look at cases like the Occupy Toronto case. Council may remember back, I think it was in 2011, there were a number of people that were living in a park protesting a number of things, including, and so what the City of Toronto did in that case, they issued eviction notices, and those including trespass notices based partly on their bylaw. They had a parks bylaw that restricted some of the structures in the park, but they also issued eviction notices so that those individuals could not spend all night and basically live in the park to the exclusion of others. Those trespass notices and eviction notices were upheld by the court as they were found to be minimally impairing the rights and to be proportional to what was happening. So they were allowed to protest, peacefully, but they couldn't occupy the whole space to the exclusion of others. And so that was the balance that the court found to be appropriate in that case. So council has, in sort of going through this, a number of tools available in terms of looking at achieving the goal of providing us safe public spaces and having some control and regulation over the use of City Hall property, but also other public spaces. We've talked a little bit about them in various instances, so special event policies, you can pass bylaws that do have bylaws that require permits for the use of certain areas, like roadways, for example. You also have the availability of using trespass notices. As I mentioned, there's a range of what could be appropriate in that instance. And obviously the injunction, the type that's mentioned in the motion before you today. It is possible for the court to consider criminal activity or mischief, civil disobedience as something that could be considered in terms of an injunction. The city may, obviously, you may remember the injunction on the Red Hill Valley Parkway. So protesters were trying to block the development of the Red Hill Expressway. It was found in that case the city was successful in getting an injunction in that case, and the court did say that interference with property rights, enforcing municipal bylaws, or restraining civil disobedience, if the person bringing the injunction can prove a serious issue to be tried, then the injunction could be granted in those circumstances. That said, I mean, there's obviously all of these types of cases are going to be very fact specific in terms of whether there is bylaws in force, whether there's private property rights versus public property rights. So while it's certainly possible, there's obviously chances, risks associated with it and challenges. So in order to be successful on an injunction, the court will apply a three-part test. So whether, number one, there's a serious issue to be tried, whether irreparable harm will ensue if the injunction is not granted, and the balance of convenience must lie in favor of granting the injunction. So obviously, so challenges, some potential challenges in terms of looking at the injunction, whether or not we're able to demonstrate irreparable harm, so the need and the urgency of the injunction and whether it's necessary. In this case, we may have some challenges, we may have some good arguments. We just not able to really give you a full assessment at this point, but that's certainly a potential area of a challenge rather. Identification of the individuals in particular that are undertaking the criminal activity or the inciting of the hate. So the municipality versus the police have different abilities to require identification or to be able to identify people. So we may have challenges identifying the individuals, and that may have an impact on our ability to be successful on the injunction. In particular, the motion mentions preventing groups of people from using the property. That certainly would create more of a challenge to identify a group and be able to identify them without it being overly broad. So that's a potential challenge. Looking at the enforcement of the injunction, if granted, having specialized staff available to assess that particular interpretation of the injunction and whether to know when to call the police. The content of the injunction, as I mentioned earlier, would need to not be so overly broad as it prohibits any demonstrations anywhere in the city, so that would need to be addressed. As I mentioned, freedom of expression is protected, but with reasonable limits, so we would need to show that the actions being taken are a reasonable limitation on those freedom of expression rights. The challenges, so a couple of risks that come to mind in terms of proceeding this way. Certainly looking at the court coming down with a decision that makes it challenging to come up with a solution in the future. The flip side, obviously, is it could be of assistance if we get a positive decision. Looking at the type of injunction that the court might be willing to give, it may be that they restrict it to the criminal behavior that's mentioned in the motion, but make it clear that other forms of hate expression that aren't protected, or that are protected as freedom of expression. So it may be that without getting so far as to inciting violence or being violent, that other forms of hate speech which are protected would still be permitted. And certainly that may not get all the way to where counsel is wanting to go. So that's really what I have for the moment. I've tried to pull together sort of what I can in terms of general background and some information on what's available to you. I look forward certainly to being able to review all of these tools that are available to counsel in greater detail, including the special event policies, trespass notice bylaw policy, and whether what availability the injunctions would have with a fulsome review and providing recommendations and advice to counsel so that they can achieve what your goals are in terms of having the forecourt be a safe, accessible space to all residents in the city. I'm happy to answer any questions.
Okay, thank you. And I would say that's a pretty good effort in a short period of time on this significant issue. So I appreciate your good work on that. Councillor Clark.
Thank you. I agree, Mr. Mayor. Thank you very much for that. So